I'm Stephen Gold, the author of The Return of Breaking Law. You may remember the case of a music teacher who was duped into instructing her bank, Barclays, into transferring £700,000 into an account controlled by fraudsters. The money, life savings, belonged to her and her husband, a retired consultant physician. We rejoiced, didn't we, in the decision of the Court of Appeal to allow the couple to continue with their claim for compensation for their loss, which was against Barclays, and Barclays had been attempting to get the claim thrown out on the basis that the law didn't allow a claim of this nature. Well, forget everything I said. Cancel the garden party set to celebrate the decision is now been reversed by the Supreme Court. The position now then is this: if fraudsters themselves induce a bank to give them your money without your knowledge or consent, the bank can be successfully sued if it knew of the fraud, it shut its eyes to the obvious, or it acted recklessly in failing to make the inquiries that an honest and reasonable bank or person would have made before giving away what was yours. However, this does not apply, ruled the Supreme Court, where, as in the case we're looking at, the instructions to transfer the money were given not by the fraudsters, but by the bank's own customers. The Supreme Court did accept that a bank could specifically agree in its standard terms and conditions in this sort of situation that it would be liable to a customer where it had reasonable grounds for believing the customer had been tricked, but Barclays' standard terms and conditions didn't say this. All may not be lost for the couple. They've still been allowed to continue their claim on the alternative ground that Barclays failed to act promptly in recalling the transferred money after the fraud was discovered. Now, the Financial Services and Markets Act of this year provides for a mandatory reimbursement scheme for certain victims of bank fraud, principally consumers and charities, in relation to what are known as faster payments. Well, this part of the Act, alas, has not yet been brought into force. The Civil National Business Centre. What do you suppose goes on there? Flag manufacturing? No. Banking? No. Ice cream whipping? No. The administrative work involved in the civil law system? That's what goes on. The name must have been chosen out of a hat by a blindfolded civil servant, as nobody would have guessed from that name that the centre, which is in Northampton, does what it does. What the court service has done is to merge the County Court Money Claim Centre, which dealt administratively with small claims as well as other stuff, and the County Court Business Centre, which had been based in Salford and dealt with paper claims and certain enforcement. And the new merged centre has just got going. You probably don't give a fig about this, and who could blame you? It's just that if you are posting a claim form or other document which would have gone to one of the other locations, send it instead to the new place. A tenant of a house or flat on a long lease will normally have to pay the premium or a contribution towards it of insuring the building. This will probably be part of the service charge. In the ordinary course of events, the premium payable has got to have been reasonably incurred. If it wasn't, then the tenant can challenge it by going to a residential property tribunal. These challenges aren't easy for the tenant. The landlord doesn't have to show that premium charge was the cheapest on the market. If the landlord approached a reputable insurer and the premium negotiated was in the normal course of business and reflected what the insurer would normally charge for business of that kind, then the tenant is likely to fail in a challenge. But successful challenges have been made. In my book, I mentioned one particular case where the tribunal was vindicated on an appeal in reducing 3 premiums respectively from £12,598 to £2,803, from £12,670 to £2,819, and from £11,150 to £3,017. And if a landlord and insurers have been up to some monkey business together, the tenant could be on strong ground. Sometimes the landlord will own a number of properties and take out a block policy on a lot of them. Then the landlord would need to prove that this hadn't resulted in a substantially higher premium which had been passed on to tenants of a particular building without any significant compensating advantages to those tenants. All of which takes me to an appeal just decided by the upper tribunal. That appeal involved 2 North London blocks of 157 flats and challenges by the tenants of 49 of them. They contended that the costs of insurance for their buildings had increased by more than 118% compared to the previous year, and notwithstanding that the average increase suffered by 6 immediately neighbouring blocks of similar size had been a mere 17%. The challenges against the landlord had been killed off by a first-tier tribunal because the premiums were contractually payable by the management company and not the landlord, although the insurer was nominated by the landlord, and in practice the policy was placed by a company which is a member of the same group of companies as the landlord and which invoiced the premium to the management company. Got it? On the appeal, the killing off was reversed. It was held that a challenge under the Landlord and Tenant Act of 1985, these challenges are made under that Act, is still available even in this situation. The original tribunal will now have to decide whether it was all reasonable.